Good morning, everyone. My name is Nigel Gooding, the founder of the Data Privacy Advisory Service, and welcome to in our series of webinars responding to rising data subject access request rates. We'll give it a couple of minutes before we kick off. I can see the room filling up. We've got 70 people, 72, filling up nicely. So we'll give it a couple of minutes and then we'll kick off because it's just dead on 11 o'clock. I'm not quite sure what time it is where you are, Joss, but it must be early in the morning, I suspect.
Where are you based, Josh, at the moment?
It is, but often up early, so excited to get started. Right now
Cool.
I'm in Washington, D.C.
Cool.
4 o'clock, maybe 7 or so.
6. So yeah,
6. Yeah.
no.
One of my fellow PhD students at Falmouth is from New Zealand, and when we do webinars, it's always in the dead of night for him. I feel sorry. I feel sorry for him. At 2 o'clock in the morning, he says, "I have to go. I can't survive anymore." Well, welcome everyone. Good morning. We've got 100 people signed in, which is absolutely lovely. Thank you very much for coming. Nigel Gooding here from the Data Privacy Advisory Service, founder. I'm moderating the wonderful session we've got today, responding to rising DSAR rates. Josh, I think you're driving, so if you could press the next button really on the slide, that would be really helpful. Just a bit of housekeeping, ladies and gentlemen. If you would like to ask any questions, please put them in the chat box. We'll deal with them at the end, and I will then present them to Tash and Josh. I might invite you if there's time for you to ask the question in person, but so please put your questions or thoughts in the chat box, and I will moderate them. Just remembering that clearly from a Data Privacy Advisory Service, we don't necessarily just provide webinars. We provide handling and redacting subject access requests. I've been into the subject access request team this morning, and they're very praising Josh's tools from Phase Law, and he'll tell you a bit about that. We've also got a number of courses and the subject access request report. So that will be the last sales effort from me. I'm going to hand you over to our two esteemed professionals here. If you want to see their full resumes, please go on LinkedIn. They're absolutely fascinating and really experienced practitioners in the field of data subject access requests. Tash Whitaker joins us from Whitaker Solutions. Tash describes on her LinkedIn profile, she is passionately curious. You can define what that means, and I'm sure Tash at some point will tell us. And we've got Josh Schwartz who is the CEO at Phase Law, who on his LinkedIn profile says he's a coffee enthusiast, and at 6 a.m. in Washington, D.C., no doubt he'll need that. So Tash and Josh, I'm looking forward to this. All yours.
Thanks, Nigel.
Thanks, Nigel. Great. So we will go ahead and get started. I can introduce the agenda and then we'll dive in. So start off and talk a little bit about why we think volumes are rising, kind of the landscape of how things are changing in terms of request volume and request scope. We'll talk through some changes under the DUA. We will talk through kind of what it looks like to push back for things being not reasonable or proportionate, and then also how folks are kind of applying the manifestly unfounded standard. And then we'll talk at the end about just some tips and tricks for making the process survivable overall. So I'll jump in. And yeah, why don't we talk through DSAR volumes? Tosh, do you wanna kick us off?
Yeah, I've literally been doing SARS since the 1st of January non-stop. I have seen such a massive increase. I mean, I work primarily with the private sector, so I'll rely on you to talk about the public sector, Josh. But what we're seeing is it's not so much SARS from customers at all. That hasn't changed. It's SARS from existing and ex-employees. Um, and yes, there is a growing public awareness. I don't know if anyone has seen the Joe Lycett sketch where he's actually is a UK comedian telling people how to submit a SAR. But what I'm also seeing though is people using AI to write their SAR request. Um, And that has its own challenges as well because it asks for things which aren't necessary, or not under the scope of a SAR. And so you end up sort of on the back foot right from the beginning as well. And that can be quite overwhelming with the number coming in with these massive, massive requests. It's huge right now.
Yeah, and I mean, just to add to that, I think, on the AI side, a few interesting things that we're seeing. One is, it's not just SARS and it's not just the UK. So we're hearing about increases in FOI requests that are kind of driven in exactly the same way. We're also hearing about, AI-driven pushback, so that, as soon as somebody gets the response to the SAR, they drop it into an AI tool, and then come back with a bunch of kind of follow-up questions or concerns and whatnot. So definitely, this kind of world of AI authored requests is kind of changing things across the board. And yeah, the same thing in the public and in the private sector. Um,
It's worth knowing, Josh. Yesterday, I think it was, the ICO put out some guidance on AI requests for FOIs and where you can push back and some sort of guiding principles on it. It was quite good. I think Claire Archibald has put a good LinkedIn post all about it. Definitely worth going to look at because I think there are things there which you can apply to DSARs. Not all of it, obviously, but there are some things that you can apply to DSARs. Oh, thanks. I think Ruth
yeah,
has
it's
just put it in the
interesting.
comments.
Oh, great. Yeah, yeah, it's interesting reading through that guidance. I mean, I think, the biggest takeaway for me, and I'd be curious if you had other takeaways, is, the reality is that whether somebody uses AI to author a SAR or not, we obviously have to honor the SAR. So, I think the big thing that we see is, like, sometimes these SARs have incorrect, stuff in them, and if somebody says something that's wrong, they ask for something that's not, not present under the law. You can push back, but you can't just say, well, this is clearly A authored, so we're not going to respond at all. Um,
Exactly. You still have to respond to them. And what I've started doing now is when I'm responding, I'm giving a very similar response to everyone. I'm not going into a detailed, well, we're not going to give you this, we're not going to give you that. I wait for that till the very, very end, till we're actually giving the data back and then explaining what we have and haven't done. But even then, I don't even go into the detail because quite often I don't think they know what they've asked for. They've just generated something from AI. They just wanted a SAR. So unless they push back and go, well, why didn't I get my metadata and my 4 drafts down the line, this sort of thing, then we'll go back and say, well, actually, the fact that John Smith opened this document is not your personal data, therefore you don't get the metadata. And, yes, there were drafts of the document, but they didn't contain any different personal data from the one that you've got. So, it is what it is. But as a general rule, I try not to get into an argument up front now. I'll save that to the end.
yeah. And for these AI authored requests, one thing that I think I'm hearing is that they're more likely to be general. They're more likely to say, give me everything and actually enumerate, look at all of the text messages, look at all the Teams messages, look at all, and whereas a normal person writing a request might not think to even come up with all of those different places somebody's asking you to search. Are you seeing that same sort of thing where it's it's these kind of much more broad SARs that are coming in this AI authored sense?
Definitely. And what we have to be careful about is the line that says, I want a copy of all my data, including but not limited to, and then 4 or 5 or 6 or 7 or 8 or 9, lists of things. And quite often a client will look at that and say, well, they just want this. It's like, no, that's not what this said. So that's when we go back for clarity on it. And we might try and frame the clarity of, you said you want these 6 things, just to confirm that's what you're after. But we do have to be careful because if they have said, I want everything, including but not limited to, then they did mean everything. So that clarity can be really important. But yes,
Yeah.
you're right. They ask for things which just make no sense. They say, I want all text messages between X and Y, between John and Jane, and I want to know who else you looked at. It's like, no, 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 not happening. We will do a reasonable and proportionate search across our systems for personal data that you are entitled to under this SAR. End of.
Yeah.
And just leave it at that. Try not to open it up to that level of detail.
Yeah. The one other thing that I'd add just on that while we're on the topic of AI SARs is I do think that they also raise the stakes around making sure that you have done your redactions correctly, and you have yeah, and you're handing over the data that you should and not the data that you shouldn't. It's trivial to drop a giant PDF into ChatGPT and say, are there any things that are just black boxes but aren't actually redacted in here? Or, are there, summarize, in this 1,000-page bundle, summarize all of the things that are being said about me. And so you should be prepared that it's, whereas I think previously when somebody got a 1,000-page PDF, it'd be pretty hard for them to actually, read and find anything in there. Now, I think with an AI tool, it makes it much easier to extract anything that's kind of spicy in there. So I think it just raises the stakes a
Yeah.
bit.
And we've seen examples where people have come back and said, you've included someone saying, this comment about me. That's just not right. I want you to rectify it. You're like, well, hold on a minute first. Or, you shouldn't include this. It's not personal data about me. Well, it is personal data about you. We are processing it, so we have to include it. We are not identifying who said it. Absolutely not. And there is actually nothing to rectify. If it's an opinion that someone has said about you, it is what it is. There's not a lot we can do. So we do see sometimes they lead on to rectification requests or they lead on to deletion requests. But also, more often than not, they don't even open the file that you sent them. They don't even
Definitely.
want it. They were just being really annoying.
Yeah.
And I
Yeah.
find that quite sad when that happens, because you sort of know your gut knows that they're just being obstropolous, but you can't prove it ahead of time. So you can't say you're doing this to disrupt the business or anything like that. They're putting in a genuine SAR. You have to just abide by it.
Yeah. Yeah. Absolutely.
The last point on this one, the operational burden of managing SARs end to end, I find this one interesting. I've got a number of clients who, I've been working with them for, a year or something, doing their SARs for them. And they're now at the point they say, we actually want to do our SARs ourselves. Obviously, it's an expensive thing to do. We tend to say, if you're looking at a SAR, you're probably looking at 3 to 5 days of effort once you've extracted the data for us to do in scope, out of scope, what's included, what's not, redactions and everything else. And I think they say, oh, well, we'll bring it in-house, we'll do it. But it's not an admin job doing a SAR. And that scares me a little bit because, yes, you can show someone how to use a tool. Yes, you can, get them to say, oh, that document's not in scope. But there is so much nuance inside a document. When you're looking at disciplinary statements and things like that, you've got to be so careful not to be identifying another person. This person said this about you, and making sure you're not including mixed data where you really can't separate it out. And I do worry that their businesses are starting to see it as an operational task or an admin task, and not a no, what we're providing is a defensible position for you. I can justify everything that went into that SAR and everything that didn't go into that SAR. So it's much more than just an admin job. It really is.
Yeah, I think that's right. I mean, I think that's one thing that we see, organizations handle these requests so differently, and I think a lot depending on just sort of what volume of requests they get. So, I think we see a lot of smaller businesses that maybe don't have a full-time data protection person, and maybe somebody from HR is doing it if it's an employment star, or just an operations person is doing it. Might have no training in data protection or no specific background on what they're doing. And really what they often think about is, I just need to redact the names and that's kind of it, right? So that kind of more sophisticated thing, I think is there's a reason why this is something that professionals handle, whether that's a professional on staff or a professional like yourselves or like our friends from DPAS. But I do think it's very important that somebody have training and know what they're doing in this work.
Yeah. And as
Both
you
for
go,
speed
sorry.
and for accuracy. Yeah.
And as you go through a SAR, you start to notice things as well. I think Emma's talked about the background to the SAR. There is the background to the SAR, but there's also a story that you learn as you go through the SAR. And then you'll see someone say, and you showed me the CCTV. And I'll be like, there should be CCTV with this because they've talked about it. Or they'll say something like, and this was on the Facebook group. You're like, is there a closed Facebook group I should know about here? And things like that. And if you're just treating it as an admin, you're not having this, dare I say it, Nigel, this curiosity that I talked about, this nosiness of, oh, hold on, there's something else here that you've missed. Go back, we need to search that, add it to the process for next time, and things like that. It's that inherently curious as you're going through it to make sure you're capturing everything you should be. Because all the time you're thinking to yourself, what are they looking for? They're doing this for a reason. What is it they want? And why can't I find this smoking gun? So at the same time as, going through the redactions, you are also looking for that smoking gun because you think it probably does exist. I haven't always found it. Sometimes it's just not there. People have had the conversations in person instead of on email, which is always very nice. And it is what it is. But if you put yourself in the shoes of the data subject and be constantly looking, I think that does help.
Yeah. Well, I'll be very curious, Oh, sorry, go ahead.
Tash and Josh, sorry, I said I'd ask questions at the end, but
Oh no, go for it, please.
It's relevant. Emma Hughes asked, are we allowed to ask of those something specific they want?
Yes and no. So, any of those that came to Privacy Space a couple of weeks ago would have met Dom Smith, who is part of the SAR team at the ICO. And he gave quite a lot of advice in this area about how you clarify things down. Now, you have to be careful how you clarify. You cannot be seen to be trying to narrow the scope. Because that's not what clarification is about. But the ICO were fairly good on saying you can say, is there something in particular you're looking for? Is there somewhere you particularly want me to go and look? Is there a timescale you want us to look for? And that sort of thing. So you do have to be careful because you can't be seen to trying to bring it down. But equally, if they are looking for a smoking gun, and I would say probably 80% of the ones that I get, they come back and go, no, give me everything. You're like, okay, fine,
Yeah.
we tried. But then on other ones, I have had it narrowed down to a 1 year instead of a 15 year. You're like, thank you. That's so much easier. So that it's worth trying with each one. There are some that we get where you look at it and you go, do you know what? That's a beautifully articulated SAR request. There is no clarification I can possibly justify asking here, and just go ahead and do it. But yeah, so yes, Emma, you absolutely can. But be very, very clear on why you're doing it, and you can frame it around, so that we don't provide you data you're not really interested in, is there something you particularly want, and sort of position it that way.
Yeah, thank you.
Before we move to the next slide, maybe the one last thing I wanted to touch on, Tosh, you mentioned this kind of public sector versus private sector divide. And I thought I'd just quickly touch on, I think actually the public sector, if anything, we've seen a greater increase in SARs. So, I think to me, when I think about messy and complex SARs, obviously employee SARs are kind of the first thing that comes to mind. But I think those sorts of messy SARs really come up in any context where an organization holds unstructured data about their customers as well. So, if you just hold transactional data in a database, it's often pretty easy to respond to a request. But we see, I think actually the two sectors that we see the highest SAR rates, or maybe three sectors, are healthcare, social housing, and schools. And definitely, I think our school customers are just absolutely overwhelmed with SARs. And our social housing, customers are seeing, 50% or 100% rises in SARs as well. So, just the burden in the public sector, if anything, is exceeding the private sector rate of requests.
I just want to pick up on the public awareness of subject rights. I think one of the reasons we're seeing so many more on ex-employees is I'm seeing so many lawyers now saying the first thing they say is go and submit a SAR because they don't want to do discovery. They want to just go straight in, see if there's something there. And that's really annoying. When you look at the legislation and the recitals, you can see that clearly isn't what it was for. It was not for discovery. Unfortunately, our information commissioner stood up did a talk a few months ago and actually said that SARs should be used for discovery, which was really, really unhelpful because they are two completely different processes. And that's not the intention of the SAR. Europe have been pretty good about case law of trying to narrow things down to say, no, it's that a SAR is there for a reason. But the UK at the moment it's reason agnostic. A SAR is a SAR, regardless of whether you were told to do it by a lawyer or whether you're doing it to check, are we lawfully processing your data or not?
Yeah, and it's quite interesting, Tasha, to say that and that with in the UK, the reduction of cases of which legal aid could be used for, so therefore funding by using legal aid, that a number of people then thought, well, we'll give it a chance through a SAR and use it through discovery. So that's a
Yeah.
really good point. Yeah.
Yeah. Can I answer a question that Victoria's asked?
Yeah, go on, you go for it. That
This
saves me
one
reading it out.
This one comes up an awful lot for me. So you have an employee that's gone through a disciplinary process. They've been given a disciplinary pack at some point, which has so much in it, it's unbelievable. It still makes me sweat when I see it. But I'm not getting involved in that because that's to do with the disciplinary process, not to do with the SAR. They then raise a SAR, and you're left with this question of a SAR does not entitle them to personal data about other people. They've already had the disciplinary pack that has that data in it. What do you do? So I have some clients that say, do you know what? If they've already had the disciplinary pack and it was done recently, we just don't resupply that. Okay, I'm not saying that's right or wrong, or we resupply it unredacted. Everything else we redact. Then we have other clients where we basically say to them, don't forget that, by the way, there is no exemption for they already have the data. That's
Yeah.
really important because that's one of the myths I see all the time. There is an exemption from the right to be informed if they already have the data, but there is not an exemption under a SAR. They already have the data, therefore you do not have to supply it. Also, you don't even know if they've still got the disciplinary pack. So my preferred option, I'm afraid, is to say this is a completely separate legal process to your disciplinary. A SAR entitles you to this, and we do redact out. And there are some witness statements we won't include if they are too identifying to the individual. So we do tend to redact them, which I know someone else is saying they wouldn't do because it looks obstructive. I tend to just go straight down the line. I am very much if the law says this, then that is what we do, and we treat the SAR completely separately from the disciplinary process. So
Yeah,
it depends what the business wants, I think.
yeah, and just to add to that, this is a discussion we've had with some of our law firm clients, around, to your point about this being separate from discovery, if something is also going to tribunal, the evidentiary rules, in a legal setting are very different than the exemptions that we're dealing with in SARs, and you just have to treat them as separate things, right?
Yeah.
You obviously can't apply, legal rules here, and you can't apply these. So I think often when something is going in that direction,
Yeah.
you're redacting documents and you know that the unredacted documents are going to be released eventually, but it doesn't mean that you're supposed to release
Yeah.
the unredacted documents.
Exactly. And on
Yeah.
a similar note, you are allowed to provide details about an individual if they've consented or didn't reasonably withhold. I can't remember what the wording is. I should probably have written that down beforehand. You can supply data about other people, but as a general rule, almost every client I has just had a blanket no. With the turnover of staff, we're not going to go back and look for someone who left 6 months ago to ask their permission. It's not fair on our employees to have their data out in the wild like this. So there is just a blanket no for almost all my clients of we do not provide data, whoever the people are, even if it's the manager, their data is just not included. End of. And that does make
Yeah.
it a little bit easier when you're using tools for SAR redaction because you can just highlight a name and say redact across the entire case, please. You don't have to do it. Well, actually, is it fair enough to leave their name in here because it's just their HR record stating this is their manager and they knew it was their manager? It's easier just to say one way or the other, yes or no. And if it's no, that's so much easier.
Yeah.
Yeah,
Well,
and
why
that's
don't
our
we
experience as well,
oh,
Tash. Yeah.
oh, sorry.
Yeah.
I was gonna say, why don't we charge ahead? We've got a few other slides, so why don't we charge ahead and talk about what's changing? I think we touched a little bit on sort of how to think about a reasonable search, but yeah, Tosh, how are things changing for you under the DUAA?
So we always did what the ICO guidance said anyway. So we've always done this, but it has now sort of framed our responses back a little bit more of we have carried out a reasonable and proportionate search, is in every single one. But also what we've started doing now on some of the companies that are getting a lot of them, we started off first time round of checking every single possible source of data from our ROPA. Now, what we've started doing to see what is actually proportionate is as we load the data into the SAR tool, we tag the source of it. So we will load the HR data first because we know the HR data is absolutely going to be needed. Then we might do email data. And then after that, we'll do SharePoint data. So we load it on top because of the deduplication, but we flag where it came from. Then when we finish the SAR, we will start looking at, okay, did we actually get anything from the SharePoint, or did we end up putting, 15,000 documents out of scope and actually nothing came out of that SharePoint? So could we in future for this type of data subject not do the SharePoint search? Or can we not do can we do the SharePoint but remove anything that's an Excel sheet, because we know Excels came from all the other sources that we've already redacted. So we're starting to work out, on a sort of on a client by client basis, what we can then consider to be reasonably proportionate next time for that type of data subject. We know a particular type of employee is never going to turn up in the Slack extracts because we've done 4 or 5 of them and they've never turned up in the Slack extract, and that was an awful lot of work to look for them. Therefore, we don't do it for that particular data subject. So that's the biggest change, I'd say, now that it's enshrined in law, is we're starting to put these processes in place to look at what is proportionate for this client for this particular data subject and make it a repeatable process.
And have we seen a definition of what, is there a formal understanding of what it means for something to be reasonable or for something to be proportionate, or is this really kind of up to our judgment and then ultimately up to the ICO's judgment?
It's going to be up to us, but it's got to be defensible, I think. So you've got to have a pretty good logic behind it. What I do see, which is interesting, is I read this very much as reasonable proportionate search. That means I go away and look for the data. Now, I'm also seeing it be interpreted by some DPOs as reasonable and proportionate redaction or inclusion after the search. And I'm not sure about that. I haven't quite gone down that route of being able to say, do you know what, every single one of these types of record we're just not going to include. I think if it came back in your initial reasonable proportionate search, you should then treat it thoroughly once you've got it. But I think that bit is very much open to, do they mean the search or do they mean the processing of it? I think that's a little bit debatable. But
Yeah, that's a very interesting
yeah.
point.
And then the stopping the clock, we've always done that. What I'm finding interesting though is I don't just deal with the UK, and I have to remind myself that reasonable proportionate searches are not even guidance in some countries. So I have a Polish client, for example, and their DPA, their Data Protection Authority, has said the absolute opposite, and they have fined people for not doing a thorough enough search of finding things. So you have to always remember, what entity am I representing here, and what does their Data Protection Authority actually ask for? But in the UK, I have to admit, it is a lot easier for us. We are, dare I say, as a data protection practitioner, lucky that we do have that guidance and now have that enshrined in law. I'm sure there is another take from the data subject's perspective of, no, this is not fair, you must be absolutely thorough. I can see both sides, but my side right now is the one doing the SARs, so I appreciate this guidance and this law change.
Yeah, yeah. Um, all right, well, why don't we continue on? All right, great. So yeah, so we were just chatting about reasonable and proportionate a bit. Are we seeing pushback? Like, have you seen an instance where you've given somebody a request and they've come back and said, I think there's something missing. What is this overly narrow? Yeah. Are you seeing pushback at all?
I haven't seen pushback. Well, I haven't. The pushback I've seen has been for things they're not actually entitled to. So they get the results, they're like, but you didn't include my reference. I particularly asked my reference. It's like we explained to you already, references, confidential references are exempt from a SAR, so you're not getting it. Or they want a copy of a policy. It's like, okay, this is not something that we provide in a SAR. It doesn't mean that the company couldn't provide it if they wanted to, but it's not strictly part of the SAR. So I don't think they're pushing back on the narrowed scope. at all, but they don't understand what they are and they're not entitled to. So I've
Yeah, yeah,
definitely not had a problem with the scope, if I'm honest. I
yeah.
think Nigel's put something in the chat around what counts as reasonable and where that originally came from, which, is probably good background reading there. Um,
You know, that's my pet subject. That one, Ezra versus Welsh ministers, is my favourite case.
I'm just going to have a good read of that. But
Yeah, indeed,
Well,
indeed.
the background was bizarre because it was actually Ezra who suggested to the judge that there wasn't a reasonable proportionate search, and the judge nicked the term reasonable proportionate. So, yeah,
interesting.
so we've
Cool.
got a couple of questions.
Yeah.
Before we lose the plot, or I lose the plot. If you do need to gain consent from a third party, would you seek permission from the data subject to contact the people involved? And that's come from Sarah Hook.
I can't see a situation where you would, no. If you're gaining consent from another individual to be included in a SAR, see, this is a difficult one. This is where I wouldn't try and get the consent. If I thought there was any reason at all why the data subject wouldn't want that person to know they've raised a SAR, because if you think about it, that's the only reason you'd go back to the data subject and say, are you okay with this? If I thought they wouldn't want that individual to know they've raised a SAR, I would consider that to be no. In that case, I'm not asking for consent and they would be redacted out. So
Mm, okay.
no would be my answer there.
Cool. Okay. And then the second question from Paul Albert. What if a resident asking for information about emails from officers within the business, would these names be redacted?
I would. Quite often we get things saying, I want all emails from this person to this person, and this person to this person, and this person to this person. And I try not to even reference the fact that that's what they asked for. That might be how we do our search to make it reasonably proportionate if that's what they've asked for. But I absolutely wouldn't be telling them, yes, we did ask this person, and this person. And I would be redacting out their names because I just don't think I don't see that as being any different from a wider SAR where you would redact out names anyway, unless this is something where all those people had said, oh, she said she's going to raise a SAR, it's fine to have my name in it. No, but generally I wouldn't. I mean, I get very, very nervous. There's a thing on LinkedIn right now. I think she's an accountant in Dubai, who is over in the UK at the moment attending the hearing of a stalker, and it's a stalker who has been stalking her on LinkedIn, um, and he's now up in court for various other things as well. She's never met this person in her life. He has just latched onto her. And my real worry with subject access requests is that if names of people are included in there along with things they might have said or things they might have done, that's a threat to them. It's potentially a threat to their safety in this day and age. Which is one of the reasons I don't even like my name being on the ICO register, and I tend not for my clients to have my name down as the DPO. It will be DPO at. I just don't think we're in a safe world these days where releasing anybody else's name, unless you absolutely have to, is a good idea.
Yeah, I 100% agree with that. Josh, one for you, really. And Ian Taylor's asked the question, and forgive me, I didn't realise there was the chat section and the Q&A section, so well done, Ian. Are there any tools for SARS redaction and even discovery that you would recommend? Well, we at DPAS use Phase Law, Josh, so I'm going to do the sales pitch. But Josh, it might be worthwhile just sort of giving a quick overview. And then, Tash, have you come across any others? So let's go, Josh, go first. So.
Yeah, yeah, sounds good. Yeah, definitely don't want to do an overly deep sales pitch on the webinar, but yeah, I think we make a tool. I'm the CEO of a company that makes a tool that's kind of specifically designed for this sort of work. So basically helps with the data ingestion side. So taking in emails and Slack messages and Word documents, et cetera, helps you kind of do the search within the product. So filter down to the documents that are actually relevant, and then helps with the redaction side of things as well. When I see the tooling landscape in general, just to speak kind of beyond, our product, I think the majority of organizations are doing this work, just in PDF. So they're PDF having everything and reviewing there. I think obviously that is the least expensive, but the most expensive of your time. And so definitely is I think enormously time intensive. And some of these tasks that are very, very easy for a computational system to do, like cleaning up email threads or eliminating duplicates are things that are very, very hard to do if you're just trying to spot them with your own eyes inside of a PDF. There are other tools out there that are kind of focused on SARs. I'll maybe let Tosh touch on a few of those. And then I think for the very largest organizations, we sometimes see folks who have an e-disclosure product, so designed for more litigation-related document productions, which they will sometimes repurpose for SARs. Often, it's not the quite perfect fit for this sort of work, but if you have a tool in place, it can save budget versus buying something new.
Oh, thank you, Joss. And Victoria Clark has mentioned other products are available, of course. Tash, anything you've come across that?
Yeah, so the ones that I looked at when I chose Phase, I can never remember if it's Phase Law or Phase Lab. I use both words interchangeably. The company is Phase Lab and the
Oh yeah,
product is Phase
got
Law.
it just right.
Yeah.
Yeah.
The ones I looked at Smartbox, I looked at Nalytics, both really good products. I also looked at another one that was Windows only. I don't recall what it was called, but it was no good to me because I don't use Windows. I eventually went to Phase Law based A on the price and B on the promise of the reactivity if I raise issues. And that has been absolutely amazing. For me, that's so important because I'm quite often redacting stuff at 2 in the morning and I can ping and there will be someone who answers me. And that is just like, so it was a massive seller to me. So definitely, I think Nalytics I was particularly impressed by as well. Then Pimlock is what I use for redacting CCTV, and that is good. I say that hesitantly because I'm not very good at using software and it takes me so long to redact CCTV. But I think if you were doing a lot of it, you would get to do it, you'd get to learn the flows of the right things to do. And I find that one to be really effective. So
Yeah.
they're the ones that I've looked at.
And then I think the other things I mentioned.
Startbox went into administration a few months ago and have come back out. I don't know what their trading situation is right now, though, if I'm honest. I have no idea. So do your research.
Thank you very much. And Luke Beckley's just suggested another one for CCTV there as well. So in the chat box, there are a number of other products are available. Back to the presentation, Josh and Tash. So sorry.
Well, just the one other thing I wanted to mention on the tooling side actually is the other thing, if you're a Microsoft organization, getting really familiar with how to use Microsoft Purview, I think is really important, which is where you do your searches. Similarly, if you're a Google organization, getting familiar with Google Vault. But I think Microsoft Purview is very hard to use. Unfortunately, the Microsoft team changes the product all the time. So we see all the time people say, this is how I used to do this search. It's no longer working, or I'm getting different results. And unfortunately, that's kind of part of the work. But I always say, an extra 10 minutes in Purview could save you 2 days in redaction work, because if you can eliminate, if with a slightly smarter search, you can eliminate, 50% of the documents, it's absolutely worth it. So yeah, getting somebody on your team, whether it's IT or data protection, who's familiar with Purview, I think is really, really important.
I would absolutely back that up. One of the biggest problems I have, because I obviously get the data dump, which I then load into Phase Law. And my biggest issue is when the outsourced IT team cannot use Purview properly. And so it takes them 3 weeks, which give me like literally a week left to do everything else, or they just give me far too much. Even though I've been fairly specific on what they need to do, I'm getting way more than that. So I can't stress that enough. Being able to extract the right data in the first place, spend that time learning Purview.
Thank you very much. Back to the main feature. Sorry, I do apologise. I took
No.
a cul-de-sac there.
Yeah. Great. So maybe the last bullet point in here, Tosh, you touched on this a little bit, but this idea of how do you document your search decisions? I think your idea of kind of categorizing things by where they came from. So what was the custodian or what was the system, I think is a really good idea. The other thing, maybe this is slightly downstream from the actual search side, but definitely we would really strongly recommend, as you're going through and removing documents for scope, keeping track of what your justification is. So if you're excluding something because it's out of date range, keep track of that. If you're excluding something because of it's an exemption, keep track of that. And we see folks tend to, kind of produce a cover letter along with their SAR and sort of explain their methodology. This is what we searched. These are what we excluded. We found, 4,000 documents that were legally privileged and, 1,000 that were confidential references, et cetera. But kind of giving people a story of kind of what you've done and what you've excluded, I think is important. And you can only do that if you're actually keeping records along the way.
Yeah, see, I don't. Okay,
Interesting.
so
Yeah.
mainly because almost all of mine are excluded because they're not related to the data subject. They are business documents with absolutely no personal data other than their name in them. Or I'm redacting things because it's the protection of others or it's duplication. It's very, very rare. I might have a couple which are legally privileged, in which case I'll just make a note in my head, I've done a couple. But if I use the feature which allows me to mark every redaction as to why I redacted it, it would slow me down so much. So I end up just, like just putting, it's not personal data, or protection of the right of others on almost everything, and just making a note in my head when I have used something different from that. So we would never tell the data subject, the reason for every single individual redaction. We will say we have done this, and these are the exemptions that we've applied, and this is why. But it would slow me down far, far too much if I had to do it granularly. But I'm sure there is a use case for doing that. Don't get me wrong, but just not for me.
Yeah. Um,
Yeah.
the last thing to mention on the search side, I saw a question just or a comment come in from Amy about SARs referencing AI tools. This is actually a pet, I think challenge for me that I'm thinking a lot about, especially in this world of AI note takers, where every meeting is being recorded. I think there's this huge new risk surface in terms of just the amount of data that folks have. We're definitely seeing, Copilot, ChatGPT, come up in searches in a world where every thought somebody had is suddenly recorded, every conversation is suddenly recorded. It just increases the volume of data and increases the risk. So I think that'll be something that's evolving, but definitely getting more complicated more quickly.
Exactly. And that, it's worth remembering that within the extract that you do, you will get folders, which are the questions that have been asked of Copilot and the answers that came back. And they're actually quite difficult to sift through when you're doing a SAR as well. I think the first one I ever saw, someone had actually said on there, do not use expletives. And so the response or the thought process that happens that gets saved is a list of expletives that it's looking to make sure it's not using. And the first time I saw that, I was like, oh my God, what is this? But it is just worth remembering that there are folders on there, which are all the AI searches that have been done.
Yeah. All right. Well, let's charge along. So we talked a bit about pushback a bit. So let's talk about manifestly unfounded. Have you used or have you had clients use the manifestly unfounded pushback?
I've had it once where they had actually written down in a document, if you don't do this, I will raise a SAR, or the other way around, or is I will withdraw this SAR if you do X, Y, Z. And I was like, okay, manifestly unfounded. The downside to that is they then just raised a new SAR the next day.
Yeah.
Completely separate, like clean slate. Can I have a SAR, please? So we still end up having to do it. I also had a situation, I won't go into detail, but this guy had done multiple SARs. He wanted it all on paper. It was boxes and boxes of data. And the ICO advised us it wasn't excessive. And he had cost the company millions over the last few years in doing things like this, and we weren't allowed to consider it to be excessive. And I think, sorry, I think Dom said when he was at Privacy Space, it's a very, very high bar for excessive and manifestly unfounded. It's easier in Europe, but in the UK, it's really, really difficult to prove now.
Yeah. Yeah, I think I've seen a few clients who are trying, but I don't know that it'll be successful in the long term. So I've had folks say to me, if I do a search and it comes back with 50,000 documents, I just always tell the person that it's excessive. But I don't know that there's actually a
No,
legal ground to stand on there. So
you
yeah,
absolutely can't do that.
yeah,
The volume of data is nothing to do with excessive.
yeah,
Excessive might be that they have put the same SAR in 6 times in a year.
yeah,
That could be considered potentially excessive, but the volume of data, it's very, very clear in the guidance that is not excessive.
yeah,
That's your problem. The fact that
yeah.
you haven't got a good retention
Good,
policy
good
in
retention
place,
policy.
you
Yeah,
haven't got a good
yeah.
process for doing it, you collected more than you needed, your problem, not the data subject's problem. I actually see more, which we haven't put in here. I see more around the what I consider to be the incorrect use of complex. So where
Mm,
people ask for an extension, or no, let me start again. The controller says they are doing an extension because it's complex. And quite a few organizations I come to, they were doing that by default for all of
yeah,
them.
for
It's
every
complex,
employment style.
yeah,
Yeah,
which
yeah,
was giving them three months in effect instead of the one. To me, that's a big no. It's very rare for something to be complex. Again, they say it's complex because we've got so many systems. Tough. I've used complex where the request has spanned two controllers, two group companies over a period of time. There have been situations where we've used complex and we know that we're probably treading a very, very fine line on it, but we actually need the extension. So if we do need an extension, we tend not to even go back on the it's complex. We'll just go back and say, this is taking longer than we thought. Are you okay if we take an extra couple of weeks on this? So we're not doing an official 2-month extension, but we're having a reasonable conversation with the data subject, and they more often than not, they're more than happy just to wait an extra week or so.
yeah, yeah.
Oh, Tash and Josh, there's a question from Mark O'Brien there. In relation to exemptions, what are your thoughts around legal management forecast and negotiations? And that they could be complex, but by nature of the areas they deal with. Any examples of what should or shouldn't be included? Navigating email threads can be quite difficult. So clearly, Mark's having some worries around navigating email threads.
Yeah, so the management focus, so legal, I think you're probably talking about the
Legal
legal
privilege.
privilege.
Yeah,
I think that the definition of the exemption for legal privilege under the ICO guidance is slightly wider than the real definition of legal privilege because it does cover third parties as well. Um, but I tend to rely on the FOI version of legal privilege just because it's much more detailed and I think it stands up better. Um, for management forecasting, the example I always use here and very, very, very rarely use it is if, for example, the release of this data is going to show that someone unrelated might be getting made redundant, or a team might be getting made redundant, or something like that, as a result of you showing the data, someone would learn something they're not supposed to know that could affect them, or it could affect share price or something like that, then I would consider that to be exempt. And then negotiations. This can quite often happen if we're in the middle of negotiating a payout or
yeah,
how we're going to handle a particular legal case with this individual unrelated to the SAR. That I wouldn't include because I would consider that to be ongoing negotiations as long as that negotiation is open. If that negotiation has closed, then I think
yeah,
it's a lot harder to use that exemption.
Well, thank you
yeah.
very much.
Great. All right, let's charge ahead. I think this is our last slide before we open to questions. Oh, let's see. Was there a question? Should we tackle that one before?
Hmm.
Um, uh, um, or shall we? Yeah, let's dive in. So we've talked through a lot of this stuff, in terms of workflow and process tips. Um,
Oh, I've got a really good tip that has
Great.
changed my life. Stop using black redaction and start using white redaction. You get so many less complaints. It just looks so
Mm.
much better to the data subject. When they get loads of black boxes, they're suspicious. And quite often that black box will be, something totally unrelated. You just can't get it out of the PDF. So you're having to just black box it. But using white redaction is so much better. It's just so much more data subject friendly, more makes the whole thing more approachable in my view.
Yeah, the two other things to say there. So we actually have a customer who redacts like in a very pleasant blue. under the same logic, right? So it just is not scary. It doesn't feel scary to get a document with some blue markup on it, or some white markup, whereas it does feel scary to get something that's covered in black. So I do think there actually is something really psychological about kind of just that feeling as of it's an intelligence document almost, where it's covered in black markings. The other thing, less human but really important, is whatever you're using, make very sure that your redactions are actually redactions, right? So we've seen so many instances, including government agencies, including very, very large companies that have unlimited budgets for this stuff, where people have redacted something and all they've done is just drawn a black box over something, and then you can just highlight the text right underneath the black box.
Yeah.
So make sure that you are using some sort of product, and it can be Adobe Acrobat, but make sure you're using something that is actually doing redactions and not just drawing boxes.
Yeah. The very, very first SAR I did, we did it all printed out, black marker pen, and then we scanned it. And as we scanned it, the scanner actually picked up all the text instead of the black
Oh,
box.
no.
So it was all complete. We had to start again. So yes, I'm very relieved now that I have a way of doing it that doesn't show the data.
Yeah.
The avoiding burnout one is really important. When I first started doing SARs, I used to get really emotionally involved in them. I much less so now. I think, people did say to me at the time, oh, give it to someone who's much more emotionally resilient than you are. And I was like, no, that's not fair on my employees, is it? But actually, what I'm finding is the more I do, the less involved I get. There are some where you do spend your time going, who's actually at fault here? The data subject or the controller? Have they got a valid point here? There is a bit where you get involved. You can't help it. You're human. But I do think the more you do, the less likely it is that you're going to get burnt out from it because you don't take it on as much. But those first few, definitely, I did.
Yeah. And any tips? I mean, I was thinking about this bullet point earlier in the presentation, um, when you talked about just kind of your process for really thinking about you talked about looking for the smoking gun and sort of very carefully, considering each document. How do you do that practically when you're on the 4,000th email of a giant SAR? Any tips for sort of how you keep yourself engaged and you're not just sort of blindly going through, redacting one, just a name at a time, but not really actually thinking about what's going on in the documents?
Yeah, it's difficult. So my biggest tip that I've learned, certainly over the last 4 months, is when I had a lot of SARs coming in January, I used various consultants. There would be three of us working on the same SAR. That doesn't work. It really doesn't. Unless you've got, you can actually hive off a particular type of document and say you do all of those. But as you're doing the SAR, you start to recognize things you have already seen that the system might not have picked up as a duplicate. And so you can manually, no, duplicate, duplicate, duplicate. And because you're following the story as well, then you can quickly see, oh, I know that's out of scope. I know what that is. I've seen that before. Oh, I know that's not my data subject. That's the data subject with the same name who works in that branch, and things like that. Whereas I think when there's lots of you working on the same one, you lose that consistent story that you're following through the SAR. In terms of how do I just disengage, I don't have that problem. I'm a really, really fast reader, luckily, which is what I think helps with doing SARs. And I wouldn't dare zone out. I just can't. I have to be on it all the way because you can have a sentence in a SAR that half the sentence is data about the data subject, the other half is data about someone else. And you've got to be on it enough to know to redact the half sentence about somebody else. So
Yeah.
zoning out is not an issue. And that's another reason now that I've brought all my SARs back in-house and I do them because if I'm doing them, I'm a control freak. I know that level of detail, that level of thought is what's gone into it. And I know it's done properly. It's not just being done by someone just like, oh, that looks like a name, that looks like a name, that looks like a name. It's not that, it's context around the names, not just the names. Having software that can identify the names is helpful. And quite often that pings me to go and look at why did it flag that? And then I'll read the, right, that's why, but it's about much more than just the name itself.
Yeah. Another thing, you were talking a little bit about team, just to, and saying that you're kind of pulling everything just back to you. I did want to mention, at scale, I think, a couple of things that I would definitely recommend as best practices. So one is, I talked earlier about, somebody on the team really learning purview. Like if you're in-house rather than an external DPO, um, making friends with IT and making sure that they understand kind of what searches you need. I think often folks can feel like I've got this data back, I just have to deal with it. And if
Mm,
you can have a conversation with IT and say, this is what I need, never include,
mm,
Tosh, when you were talking earlier about, okay, this system never has relevant data in it. Just don't include it for me, right?
mm.
And so if you can have that dialogue with IT, the other thing that I think we see, which I generally would say is always a good practice if you have the people to do it, is to have a multi-step review process where maybe a more junior team member does a first pass review and then the DPO does a second pass review,
Yeah.
or if you're dividing things up, have two people check their work. But it's so, especially given the data volumes, it's so helpful to just have a second set of eyes and having that repeatable process, so you're not having to make that up for every SAR or every document is
Yeah.
important.
And what I also do with the software, once I think I've finished it, I extract it out as the one document, and then I open a new case and put that document back in the new case as if it's a fresh document, and have the software recheck it for any names that I might have missed first time round. And if I'm handing it over then to a client, I always say I would like you to do an eyeball check on it. And I've got one client where they've never ever come back to suggest any changes. I've had another client that picks things up, which even when they send it to me, they go, page 76, second paragraph down, and I'll look at it for ages and ages. I'm like, oh my God, there, I missed that. Everything missed that. So it does help having that second set of eyes for sure. And also
Yeah.
the client, for me, they recognize the names of their employees sometimes quicker than I will. So someone with a name of Tia, for example, quite often that would be thanks in advance in some emails. In other emails, it's someone's name, and so they will pick up because they know they've got an employee called Tia. So
Yeah.
things like that, the little nuances, it definitely helps to have extra eyes on it for sure.
Yeah. Well, I know that we are just about out of time, so maybe I think a really interesting question came in just a minute ago, so maybe we'll take that one and then pass it to Nigel to wrap up. So this was about deleted items. So when something was a deleted email or a deleted Teams message, how do you balance the sender's expectation that the email has been deleted versus the fact that it's still processed? I think from my view, I'd be curious if you disagree, Tosh, but from my view, from the perspective of the organization, if you have the document, you have the document, right? So you have to produce it whether it's been deleted or not. If you have
Exactly.
it, then you as the controller have the document, you have to give it.
Exactly. You're still processing it, therefore it falls under the scope of the SAR, even if it's in a deleted folder. So yeah, that would be reasonable. If you found it, it's reasonable.
Yeah. Great.
Absolutely, and I'd agree on that, Patch. And there's no requirement to reconstruct the document if it's archived and put back, but I would agree with that. Tash and Josh, fantastic sessions. Thank you very much, but I knew it's going to be anyway. Um, just wrapping up, ladies and gentlemen, thank you very much for attending. Just thinking that subject access requests, Article 15s, are whilst there are a fundamental right enshrined within UK GDPR, we must remember that it's not an absolute right. So I think Josh and Tasha has really helped us with that. When I talk to students and when I teach as well, I always suggest that what does the law say that the individual is actually required to do, i.e. as you as a data controller. And remember that the intention of the lawmakers was to balance the burden of finding and providing the information with the rights of the individual. So just think about that, and just think about the reasonable and proportionate search. About what core systems that do you have, and it might also think that when you're thinking about subject access requests, if it's burdensome, you might want to think about the records that you do keep. And the duration and also your retention periods as well, because if you don't have the documents, you can't give them and you can't search for them. So that might be a good approach to take as well. Excellent session. Thanks very much. So if you want to speak to Tash, I'm sure you can find her on LinkedIn at Whitaker Solutions. And if you want to speak to Josh, he's now starting his day. It must be 7 a.m. in Washington. You can find him. He's the CEO at Phase Law, and you can find him online. Thank you, everyone, and have a good rest of your Thursday.
Okay, thanks.
Thank you.